Hello. Welcome to another of the PsychLaw Presents Clancy Litigation Group seminars on defending against false allegations of sexual abuse. Today we're going to talk about police interrogations and defense investigations. PsychLaw is proud to present the faculty for today, Attorney Patrick Clancy, retired Sheriff's Detective Harvey Shapiro, Professor Richard Leo from the University of California at Irvine, and myself, Dr. Demosthenes Lorandos. We're going to talk about defending against our own clients' statements, either in police interrogations or worse, in coerced confession circumstances. We'll also discuss pretext phone calls and things of that nature. We're also going to talk about the proper investigation of cases of alleged child abuse. We'll discuss the investigations that we conduct and key on how proper investigation is critical to the development of the natural history of an allegation. We will show how these circumstances are critical to an understanding of the strength and weaknesses of our client's case. The first thing that you need to do in circumstances such as these, when you're thinking about interrogations or things that police have done, is to find out, has the client talked to the police? In fact, we need to find out immediately all of the people the client has talked to right at the outset of our representation. You really need to grill them about this because often they will think that benign conversations don't hurt them. They don't know about admissions. It's important that they understand this. Also, it's important that we understand the difference between an interview by the police and an interrogation. Both certainly have the capacity for admissions against interest. But the difference, you will learn, is really important. To get right into this, I'd like to introduce Professor Richard Leo. Professor Leo did his doctoral dissertation on police interrogations, on witnessing them, and on researching them, and he has published a number of articles in this field. In fact, Professor Leo is one of the foremost investigators of police investigation techniques in the United States today. He teaches interrogation techniques to police, to judges, and to attorneys. He testifies as an expert witness for both the prosecution and the defense on the issue of proper and improper interrogation techniques. We're very pleased that Richard is going to speak to you about this important subject right now.
I'm Dr. Richard Leo. I want to thank those at PsychLaw for inviting me to speak as part of their continuing education program for criminal law specialists. I'm an associate professor of criminology and psychology at the University of California, Irvine. I obtained my PhD doctorate degree from the University of California, Berkeley. My doctoral thesis was a study of the techniques used by American police agencies in the interrogation of suspects. In brief, I was allowed to attend 122 police interrogations at the Oakland Police Department in Northern California and witnessed another 60 interrogations by videotape in 2 other Bay Area police departments. I also attended 5 introductory and advanced interrogation training courses, including an advanced interrogation training course at the Federal Law Enforcement Training Center in Brunswick, Georgia, where all federal police, with the exception of the FBI, are trained. I also attended the introductory and advanced interrogation training courses from the Chicago-based training firm Reed & Associate. I've published numerous articles, book chapters, and books on police interrogation and confession. It was because of one of those articles that I was invited to attend the Federal Law Enforcement Training Center. My research has been found to be scientific in numerous state, federal, and military courts. As of October 2004, I've testified more than 100 times in 18 different states. On each occasion, I've been required to establish the scientific foundation for my research. On 2 occasions, I've testified for the California State Attorney General's office for a case in which the defense was alleging that their client was innocent because 3 juveniles had confessed to the same crime. My role in that case was to explain to the jury how police interrogation works and how it can lead to false confession from factually innocent individuals. I've given dozens of lectures on police interrogation and confession to numerous professional organizations over the years, including to judges, prosecutors, police, psychologists, and criminal defense attorneys. I've taught interrogation training courses to police investigators in Florida, Louisiana, and Texas. The Reed method is the primary method of interrogation in the United States. It was created by an individual named John Reed in the 1940s who co-wrote a textbook entitled Criminal Interrogation and Confessions, a textbook which has become the Bible of all police interrogation training in America. It is now in its 4th edition. The Chicago-based training firm Reed and Associates goes around the country putting on seminars to teach police officers and detectives the Reed method of interrogation. Virtually every detective in America has either been trained in the Reed method directly through Reed and Associates or through similar interrogation training put on by someone else or by the police department to which they belong. The Reed method was not based upon any scientific or systematic research. It was created to replace the 3rd degree, or the rubber hose in the basement of a police station when the courts put an end to that practice in the 1940s. Now, the first thing to know about the Reed method is that there's a big difference between interviewing and interrogation. Interviewing is something police do to witnesses, victims, and potential suspects. It involves asking friendly, open-ended questions in a non-accusatorial and non-confrontational manner. The purpose of an interview is to get the truth and as much information as can be helpful in figuring out the truth and getting investigative leads. The idea is to ask questions in a manner that is not leading, not suggestive, and not manipulative. The interviewee should feel at ease and should do most of the talking in an interview. By contrast, an interrogation is a very different activity. Police interrogate suspects only when they presume the guilt of a suspect, and the purpose of the interrogation is to get incriminating statements, an admission, or a full confession. It is not necessarily to get the truth. Remember, the idea is that police detectives already know the truth, or the detective thinks he knows the truth. In other words, that the suspect is guilty. And so the purpose of interrogation is to confirm what the interrogator believes, not necessarily the truth. As a result, the interrogation is accusatorial and confrontational. The detective is supposed to do most of the talking, and the detective uses specialized interrogation techniques whose purpose is to manipulate a suspect's perception. And these techniques include leading, suggestive, sometimes even coercive questioning methods. The ultimate goal of an interrogation is to move the suspect from denial on the one hand to admission or confession. The Reed method is simple to understand. The main idea, as put forward by the Reed School, is that the interrogator needs to change the suspect's mindset by raising their anxiety and changing their perceptions about what will happen to them, depending on whether or not they confess. The Reed method seeks to accomplish this through a few primary interrogation techniques. First, the interrogator seeks to isolate the suspect from the environment in which the suspect feels comfortable and from any social networks or outside support. So the interrogator takes the suspect to the interrogation room, which is typically in a remote room in the police station, and sometimes lets him stew before questioning. The idea here is to isolate the suspect and eventually to show the suspect that he, the interrogator, dominates and controls the interaction. Second, the interrogator accuses the suspect of committing the crime in a confident, unwavering manner. As mentioned earlier, once the detective decides to interrogate, he's made up his mind that the suspect is guilty and the sole purpose of interrogation is to get incriminating statements, an admission, or ideally a full confession. Not to entertain the suspect's alibi, denial, or even reconsider whether the suspect is innocent or guilty. As a result, the interrogator will not only repeat his accusations often, but he will also cut off the suspect's denial. The idea being that the less the suspect is able to verbalize his denials, the more likely he will be eventually to break. Third, the interrogator will attack the suspect's alibis or denials as either illogical, impossible, inconsistent, or simply contradicted by case facts, even if it is not, and the interrogator will confront the suspect with real or fabricated evidence, a technique that is known as quote-unquote the evidence ploy. The purpose of attacking the suspect's alibi or denials and confronting the suspect with real or fabricated evidence is to convince the suspect that he is caught, that there is no way to escape the fact that everyone will think he is guilty, and no one will believe his alibis or his denials. In short, it is to convince the suspect that he has no choice but to cooperate with the interrogator. Fourth, the interrogator in the Reed method confronts the suspect with what are called quote-unquote themes. A theme is a psychological excuse or justification for why someone would have committed an act. So, for example, in a murder case, the interrogator may suggest the theme of an accident or perhaps self-defense, that the suspect committed the crime accidentally. It was a mistake, not intentional, or in self-defense, to make the suspect feel that he is less blameworthy or less culpable for the underlying act, the death of the victim, and therefore trying to make it easier for the suspect to admit to the killing. The technique of using a theme culminates in the use of a good theme and a bad theme, which in some ways is like the technique good cop, bad cop. The idea is to contrast the good theme, for example, killing in self-defense or as an accident or mistake, with the bad theme, for example, being a first-degree, premeditated, cold-blooded murder. The idea here is to give the suspect the sense that there are only two choices in terms of how the crime will be defined and what the consequences will be to the suspect, a good choice, a bad choice, and that it is in his best interest, obviously, to take the good choice. Sometimes the good theme and bad theme even imply that if you accept the good theme, you might have no culpability or minimal culpability. For example, the officer may state that all he needs to know is whether the defendant raped the woman or was it consensual sex. The officer will want to know if you molested the child intentionally, or were you so drunk, for example, that you weren't aware of what you were doing and it was completely unintentional. The officer keeps repeating that if you choose the good theme, we can understand. Everybody makes those kinds of mistakes. Accidents happen. The officer never offers the choice that the alleged event did not occur. He keeps portraying the good theme as being in the suspect's best interest. The Reed method of interrogation can lead individuals who are completely innocent to sometimes either come to doubt themselves and their memory, and or to make false statements, false admissions, or false confessions. When an innocent individual comes to doubt their memory or make a false confession, it is of course highly counterintuitive. One can clearly see how this can happen if one understands the process of interrogation, because the Reed method of interrogation, if misused on an innocent suspect, can lead the innocent suspect to perceive their situation in a way that makes sense to question their memory or to agree to a false account. How can this happen? It happens because the Reed method of interrogation is intended to cause a suspect to think they are caught. They are trapped, and there is simply no way out of the interrogation. They will inevitably be arrested, prosecuted, and convicted no matter what they say or do in the interrogation room. This is why the interrogator exudes confidence, repeats the accusations often, cuts off or rejects any denials, attacks the suspect's alibi, sometimes relentlessly, and offers explanations and confronts the suspect with real or false evidence. The idea is to convince the suspect that the case against him is airtight, objective, irreversible. No matter what the suspect says or does, he's going to be arrested and prosecuted. It's futile to resist. Individuals who are naive or inexperienced with the police, or who have no idea that police can lie and make up evidence, as well as individuals of low intelligence or high suggestibility, may come to doubt their memories in the interrogation room, especially in response to false evidence ploys, because they may come to believe that despite the fact that they have no memory of committing the crime, they must have done something because the police are unrelenting, attacking their explanations and alibis mercilessly, and the police say they have all the evidence, that everybody is going to believe them, and it makes the suspect look guilty. Common false evidence ploys include the police telling the suspect that they found his fingerprints on the weapon, or saying that the suspect's DNA was found on the alleged victim, or telling the suspect that an eyewitness has identified him, or telling the suspect that his alleged accomplice has fingered him to the police, or whatever else the police want to make up and insists incriminates the suspect. The reason the Reed method can lead innocent suspects not only to doubt their memory, but also to make false statements or a false confession is because once the suspect is moved to the point of hopelessness as a result of the accusations, attacks on his alibi, and explanations and the evidence ploys, he may come to perceive that he has very little choice in the matter. If the suspect believes the interrogator, whether or not he continues to deny committing the crime, he will perceive that he is trapped, caught, and powerless, that no matter that he is innocent, he will get convicted. If a suspect believes this, then the good choice and bad choice offered by the interrogator's use of themes may be persuasive. Given the fact that the suspect perceives he is caught and there is no way out, even if he is innocent, he may feel compelled to take the good choice, making him appear less culpable in order to avoid the bad choice, which would make him appear more culpable. He may do this because he believes he is going to get convicted anyway, and as the interrogator is either implying or explicitly suggesting, the good choice will lead to less punishment, a lower charge, and/or a lower sentence, or possibly no charges at all. Then the bad choice, which will lead to more punishment, for example, a higher charge or a higher sentence. If the detective's use of the Reed method of interrogation is successful in moving someone to this mindset, then it may make sense, indeed, for the suspect to perceive that it is in his self-interest to make a false admission or a false confession. This may make sense because the suspect may come to think that this is the only way to avoid an inevitably higher charge or sentence, given what the interrogator has told him, even though he or she is completely innocent. An innocent suspect can be led to say and possibly believe that it must have happened while he was asleep because he has no memory of it. It must have happened while he was blacked out or drunk because he has no memory of it, or led to believe or made to believe that if he just agrees with that something accidentally happened, it will be in his self-interest. The Reed method of interrogation can be very psychologically coercive on both suspects that are guilty as well as suspects who are innocent.
Thank you, Richard. That was really informative. It's particularly important when you have the first opportunity with your client's admissions that you transcribe that tape. If you've got a tape of the interview, get it transcribed. Mark out the evidence ploys in the tape. Mark the themes with different color sticky notes or put them in a different color marker if necessary. But mark them as distinct from the evidence ploys. Mark the implied or overt offers of leniency as distinct from the themes or the evidence ploys that you notice in your transcript. Mark the implied or overt threats that you find in your transcript. Make sure that you've got each of those things marked: the evidence ploys, the themes, the implied or overt offers of leniency, the implied or overt threats, distinctly set aside and marked. What if you don't have a tape? Well, debrief your client immediately. Make sure that your client takes notes in their own handwriting. I had a circumstance once where I took notes when an expert was talking, and then the expert lost his and took a copy of mine up on the stand. Oh my goodness. The other side tried to pretend that I was telling the expert what to say. Mr. Clancy had a circumstance in which he took notes when a client was talking, and the client used his notes to refresh his memory. The prosecutor tried to make it seem that Mr. Clancy was putting words in the client's mouth. Don't do that. Have the client take notes in his own handwriting, but debrief him. Ask the client every single question that was asked of him. Ask the client how he responded. Try to get the client to tell you about themes, ploys, overt and covert offers of leniency, overt and covert threats, but don't put words in his mouth. First, try to get the information directly from him or her, and try to make sure that you understand how the client responded to each of those themes, or evidence ploys, or overt or covert offers of leniency or threats. It's important that you understand that to get an expert in on coerced confessions, or on the confession process in general, you face Daubert and or Frye issues. Dr. Leo has qualified for his testimony under both the Daubert standard and the Frye standard in California, and in a variety of courts around the country. The motions located in our CaliforniaMotions.com website will help you get an expert like Dr. Leo, or Dr. Leo if you're lucky enough to get him, involved in your case, on the stand, to offer testimony and into evidence. Mr. Clancy has made a video for you about how to access these motions and others.
Okay, now in order to get testimony in concerning police interrogations, we need a motion that shows why that's admissible. We go to CaliforniaMotions.com. You can obtain a password here if you don't already have one. I have mine, so we come over and enter my address. My password logs in automatically. And there we are. Now, using the drop-down, we're talking about the admissibility of a defense expert, and it's right here in three formats. Admissibility of expert witness on coerced confessions. It can be done in WPD, WordPerfect, or Word. Let's take a look at it as a PDF file in Adobe. And that's what it looks like. And then you can just hit Save a Copy, and you can put it directly on your own computer wherever you want it. That's it.
What happens if you can't get these motions granted before trial? Salt the record. Talk about this outrageous confession. Talk about this outrageous process every chance you get. Bring it up in opening. Bring it up in your examination of witnesses. Talk about it. Beat it to death. And then run your motion again. What have you got to lose? There are a number of judges whose persuasion we all know about who are not going to give us any help whatsoever pre-trial. So make your record and make it appear so clearly that they are going to be reversed for denying this crucial evidence that they begrudgingly let you get the expert like Dr. Leo on the stand. So if you don't win in pre-trial, salt the record. Bring it up every chance you get. It's important to realize that there are other opportunities for your client to step on his own case. Mr. Clancy will go into some of those issues.
Sometimes we have to defend against our own client's statements. One of those is when he undergoes an interrogation by the police, but the other one is called a pretext phone call. What is a pretext phone call? Well, it's legal to have an individual call a suspect in questioning. Usually this is done by the child, or if the child's not old enough, it's done by a relative of the child. They then call and confront and try to get the suspect to make an incriminating statement. If you just say you're sorry, we won't go to the police. My daughter is upset. We know it's true. Why did you do this? Things of that nature. The theory behind a pretext phone call is that the individual is caught off guard and does not have time to fabricate a story, and will give admissions to try to avoid this going to the police. What do you do with this type of statement? Well, there are several things. The first thing is that you have to look at it as to whether or not it is a coerced statement. Most people, most attorneys, do not realize that private parties, not just the police, have been held to be the cause of coerced statements, and the statements can be suppressed. We have been successful in getting a number of pretext phone calls suppressed. We have even gotten a pretext phone call that was done when the defendant was a police officer himself. Why? Because there are cases which have held that in the area of coercion, unlike search and seizure, that a private individual can also be the cause of a coerced statement or a coerced confession, and that coerced statements are inherently unreliable and therefore should not be used. The second theory in looking at a pretext phone call and doing a coerced statement analysis is that a private party can also be held to be an agent of the police. One of the things that you want to do when looking at a pretext phone call is subpoena the notes of the police officers. I've gotten notes of police officers where they have written down, quote, jack him up, threaten him with this, threaten him with that, make him think he's going to get away with it, close quote. all sorts of statements that prove that the statements being made were intended either as threats or as offers of leniency. So go for those notes. Then you need to analyze the statement as you would any other coerced statement. You would also take a look within the pretext statement, the same way you would in a police interrogation for the same type of techniques used in police interrogations. Look for evidence ploys, things of that nature. Look for offers of leniency, express or implied. Look for threats, express or implied. You can then run a motion to suppress the statement if you believe that it is a coerced statement. Here is some help for you.
Okay, we want to keep a statement out of evidence. We believe that it's been coerced. This can be from a police interrogation, or it can actually occur even during a pretext phone call. So we go to californiamotions.com. You can obtain your password here. I already have a password, and I have memorized my password. Now, using the drop-down category, this was an in limine that was miscellaneous. And what we're looking for is a motion to exclude coerced confession, and that's right here. Let's take a look at this in PDF, Word document, and WordPerfect. Let's look at the PDF. There it is, and you can scroll through it, and the points and authorities. To save a copy to your own computer, there's your own computer. All you have to do is pick out a location where you want it and save it.
The second thing to analyzing a pretext phone call is that it can be used as an open door. Many times your client's statements are ambiguous. The individual says when confronted, "I'm sorry." Well, what does "I'm sorry" mean? If somebody says, "If you do it again, I'll go to the police. If you say you're sorry, I won't go to the police." And you respond, "Well, I'm sorry." But why did they make that statement? You are allowed to introduce the suspect or the defendant's state of mind. Let me give you a real-life example. One time I had a case where a U.S. Air Force sergeant made one of those statements of, "I'm sorry." His commanding officer was the father of the child. So things that would not normally be allowed into evidence, I was able to get in through this open door. "Why did you say you were sorry?" "Well, he's my commanding officer. If I talked back to him, I would get in trouble. I would lose my position in the Air Force. I would lose my pension. I was within a couple months of retiring and getting my pension. I was afraid I was going to lose everything unless I said, 'Yes, sir, yes, sir.'" Well, normally you're not allowed to talk about the consequences of a charge of this nature with the jury. But here his state of mind was placed into evidence, and we were able to show he was conforming to the military commander, that he was afraid of the loss of his pension, and that he was close to retirement. All sorts of additional things that we could not normally be able to get into evidence were able to get into evidence through this open door. And think of a pretext phone call as an open door. You get to explain why you said what you said. And that can get in a lot of favorable material that would otherwise be inadmissible. The next area that I want to talk about is investigations. With investigations, we have a system to keep track of what we're doing on a number of different cases. Now we have a color coding system and a means of communicating with our investigator so that we don't have to drive the 30 miles to each other's offices, and a client doesn't have to drive a couple hundred miles to be with us. Let me show you a video of how we conduct our investigations, work lists, and our investigation meetings with the attorney, the investigator, and the client.
Part of being properly prepared is coordinating your investigation meetings. Because my investigator lives about 30 miles from where I do, we're doing this on the internet. what I suggest you do is go to gotomeeting.com and download their program. It's very reasonable. They charge about $40 a month. This program will allow you to have 10 people looking at the same screen at the same time. We have multiple investigators, so I call and have 2 investigators in on the meeting, and we actually have the client, who may be in another part of the state, in on the meeting. Now, I already have that on my computer, so let's go down here and launch GoToMeeting. I'm going to host a meeting and show you what it looks like. I log in with my email, and I log in with my private password. Now, I can schedule a meeting to happen in the future and send out notices to people, or I can do it now. We're going to go ahead and do it now. And we're going to start the meeting. Okay, this is the screen of the host. I want people to join my meeting, and so I can send them an email, and that when they click on the email, they see the same screen that I see. They then call in at 641-497-7010. That is a toll-free number, and a computer will answer and ask for the meeting number. There's the meeting number. You punch that in, and you are connected. 10 people can be in on it at the same time. I then click Show My Screen so that others can see my screen. And one other thing, I can give people access to use the keyboard and the mouse. I can pick one person to have access, or everyone, or 2 or 3, whatever I want. Then, by hitting this little button, everything goes out of the way. Now, what's on the screen is seen by everybody who's in the meeting, and we're all talking on the phone through a conference number. What we do then is we go over the investigator checklist that we have for each client. A few things. We have all of our ideas that everyone has is put on one document. This way there is no misunderstanding about what it is I'm looking for in the investigation. Recently I had to testify at a writ hearing, and a testimony wanted to know if I had done certain investigations. It was 4 or 5 years later, and I couldn't remember if I had thought of an idea and then canceled it. So we came up with the color coding. Green, we canceled that part of the investigation, maybe for tactical reasons, maybe for other reasons. We yellow color code anything that's a high priority, and when it's done, we red color code it without deleting it. Then, if years later you're required to testify as to what went on, you know exactly what happened with your investigation. Remember, each person can type on this. So I may talk about a neighborhood canvas, and my investigator may have a few ideas. He can take over the keyboard and the mouse, hit it, write down his ideas of what he would like to do under that. Records that we're going to have the client get, issues on alibi, other things of that nature. So everyone sees the same screen at the same time. Everyone can modify it. The clients love it because they understand what's going on, and we can coordinate multiple investigations. Then we have that client hang up, or we disconnect them and have another one come online, and we have another meeting. That's how we conduct our investigation meetings.
You've now seen how we have investigation meetings. We have our clients involved in it. We have the investigator and the attorney. Sometimes we have 2 investigators that are located in different parts of the state, all working together on the investigation checklist. By doing this, everyone knows precisely what questions I want to have handled. Too many times I have seen cases where an attorney goes to the investigator and just says, well, go out and investigate this. You know, it's one of the first of these cases I've done. See what you can find. Well, this is a misuse of your investigator. There are certain areas that have to be investigated in a child molestation allegation case, and in particular, if it's a false allegation. The first place we can start with is not what you would normally expect. We investigate our own clients. Since the passage of Evidence Code Section 1108, the prosecution has been able to introduce other allegations of sexual molestation against the client, of rape or other types of sex crimes. Sometimes our clients get a little upset that we're investigating them, but we have to explain to them that the DA will eventually get around to investigating their background. We start this investigation out with our own intake form, and on the back of it we have a series of questions for the client to tell us about any prior allegations. Now, they don't want to disclose this to you, so the form covers it in many different ways. Have you ever been arrested before? Have you ever been falsely accused before? Have you ever been accused of something you didn't do and no charges were filed? By asking it a number of different ways, we hope that they will disclose to us if there are any allegations ever previously made against them. Further, if they fail to tell us about it, and this pops up at a later time in the trial, and they tell us that they did inform us of those prior allegations, you can take out the form and show them that they did not. You need to know what's bad out there that can bump into you. Now, where do we look when we're looking at our own client? Well, the first place is we're looking at our client's other children. Many times I have found that a client had 2 or 3 formal wives, and there is only one child accusing. An offer has been made, it's a bad case, it's a reasonable offer, and the client says, I didn't do anything. We've gone out and we've investigated the prior marriages, and the children from the prior marriages, and the stepchildren of the prior marriages, and lo and behold, what did we find? The same types of accusations were being made by those children. Well, I want to know that before the DA knows it, if possible. It can definitely affect how the case proceeds. We want to know about these other allegations, whether they're false or whether they are not. It doesn't matter whether they were ever filed before under 1108, they can still come into evidence. And in evaluating your case, this is an important thing to know up front early. Now, good character witnesses, you don't need a private investigator to investigate them. If they're good character witnesses, they're willing to come to your office and you can interview them and evaluate them yourself. Or if they are from out of state, you can even talk to them on the phone. The next part of the investigation is we investigate the alleged victim. There are 2 major questions that must be answered by the defense in one of these cases. If you don't answer these questions before a jury, your client is going to be found guilty. By knowing what these questions are, it helps direct your investigation. The first question is about sexual knowledge. What if a 4-year-old makes a statement about oral copulation? The jury will believe that it's true because how would a 4-year-old know about oral copulation? Well, you're going to need to establish through an investigation whether or not they have heard it from other little children. Maybe somebody that they knew had been molested. Maybe an older brother talked about it in front of them. Maybe a concerned parent questioned them in the past about it. You need to do an investigation to determine where they got their sexual knowledge. As the child gets older, especially if they're 16 or 17 years old, that's not as important. But it's important with the younger ones and even up to the 13, 14, sometimes 15-year-olds. It's amazing how some older jurors believe that a 13 or 14-year-old knows nothing about sex. We need to establish that they know. The most important thing that you have to show a jury is the motive for a false allegation. Now, when you're doing a case, this is really the key to the case. What is the motive? There could be hundreds of different motives. I can't give you a list that would even begin to include all the possible motives. But this is what you must be looking for. Now, suggestibility is a motive. It explains why the false allegation was made. Third-party culpability. Maybe it's a 15-year-old that thought they were pregnant by a boyfriend. and wanted to blame someone else so that their boyfriend doesn't get in trouble. The alienation of one of the parents by the other parents during a divorce is a motive. In fact, it's probably the single most common motive. There are adult types of motives: hate, jealousy. Maybe the person accused married the child's parent and they didn't want the loss of the other parent. Another motive which I've seen in a number of cases is children that are neglected who are seeking attention. We have done cases of that nature numerous times, and in fact, what you are doing then is showing the lack of attention towards the child, the lack of concern for the relatives towards the child reaching out and trying to find attention by acting out negatively. That is what is doing it. Another type of motivation is the Me Too motive. I had a case in Modesto where 13 girls in the kindergarten class accused the teacher of molesting them. The actual defense had to do with the kids basically all going, "Me too, me too." All of these little girls, a group hysteria. We were able to show this because the 13 girls also saw each other being touched day after day after day. What was surprising to me is that there was no statements from the 13-year-old boys. We went and got the 13-year-old boys, and they said they had never seen anything. Finally, one of the young girls cracked. One of the 13 came forward, and that she said she had just gone along with it because everyone else was doing it, and it was fun. Me too. There can also be a situation in which you have what I call child-type motives. I had a case in which a daycare provider was accused of putting a lotion on a child's penis from a green bottle. We found out through our investigation that a week before, this child had been out on a camping trip with his parents and his sister. The sister had gotten into some poison oak or poison ivy and had touched herself in her private area, and the mother had applied lotion to the child to get the child cured. The lotion had come from a green bottle. The other little child had seen it. Well, parents know that if a young child falls down and scuffs their knee, and you have two young children, you get out two Band-Aids. You put one of these on the knee of the child who was scuffed, and you put one on the knee of the other child. I had loaded the jury with parents of young children. When I made this argument, the DA, who was a single person, laughed. She laughed right up until the not guilty verdict came back. Remember, motives have to be viewed through the eyes of a child, not through the eyes of an adult. The next thing I would like to talk about is what I call specific investigations. Why is it that you can win a trial in which 13 people are accusing your client, which I have done, and lose a trial in which 2 people are accusing him? It has to do with whether or not you have independent sources or are the sources linked. In the example of the 13 children, they all knew each other. They were all in the same class. They all talked. That's one form of leakage. In the case where it was lost, there were 2 children, independent, at other ends of the states, who had never met and who were not interviewed by the same interviewer, and they told nearly identical stories of having been molested. You therefore must determine whether or not the sources are independent or if they are linked. If they know each other, as in a class, it's easy. There are other ways that there can be linkage, though. We had a case in which there were 5 students in one class and 7 students in another class, and there was no showing that there was any cross-contamination between them. During the course of the trial, we found out that the children in the earlier year class went to a swimming pool party, which was attended by the children from the other class, and that they had all talked about the teacher and that the rumors had spread. In essence, we had one source, not 2 sources. We didn't find this out until the middle of trial. The other way that you can have linkage is essentially you have one source rather than multiple sources because of the investigator. Take the classic case of the McMartin case. There were hundreds of different children interviewed from a number of different years of attending the school. What did they have in common? They were all being interviewed by Key McFarland, who used suggestive and leading interview techniques. They were all linked. Are there other ways that you can link which might appear to be independent sources? Well, another one I can think of is therapists. Now, especially in adult cases, we had cases where there were 10,000 reports of satanic cults and people were being molested by these satanic cults across the country, and there were even baby sacrifices. This was investigated by the FBI and found to be totally bogus. But during their investigation, what they found out was that the accusers all went to therapists who had received training about satanic cults and how to interview a client about these cults. The common factor was the story was being spread by the therapists and training manuals and courses. The individuals had never met. The therapists had. Okay, what would you look for next in terms of guiding your investigation? Corroboration. You must check out all of the allegations that have some means of corroboration. You need to know both the good news and the bad news. Recently, I had a case where a child was claiming his neighbor saw a certain touch. That neighbor saw a different touch. Another person saw porno videos being shown to the child. The story was just overwhelming as you read it in the police report, until we went out and interviewed all of the children who said they had never seen any such thing, and that the little girl had a tendency of making up stories. We had one in which an email was sent in which our client was professing love and wanting to be with the child, and a whole lot of other sexual things. When we went to check on this corroboration, we went to our client's send folder in his email and found out that he had sent an email, one sentence long. The date, the time, to the 100th of a second was the same. What had happened is the young lady had added 2 or 3 more sentences to the email and then resaved it, printed it out, and given it to her mother. When confronted with the original email and the fact that we could prove that ours was the original from the computer hard drive, she confessed to adding statements to the email. The corroboration, in fact, did not exist. You must also look for the lack of corroboration, where there should be corroboration. If the person claims that an event occurred and there were witnesses present, there should be corroboration, even if the police haven't interviewed those witnesses. If you go out and find out that there is no such corroboration, it undermines the credibility of the complainant. The next area I would like to talk about is investigating the alleged victim's background. A case we handled at trial was just recently overturned after conviction based upon a writ. And in doing that, a complete background information was done. As it turned out, this 15-year-old had lied about a rape and a molestation. What was discovered after the trial is that she had admitted that she had lied to a friend of hers, who at the time of the trial was stationed overseas in the military. A year later, when a follow-up investigation was being done on the writ, going down lists and lists of people who knew her, literally 30, 40, 50 people were interviewed, the individual had returned from Saudi Arabia and Iraq and was there and had the story. Not only that she had admitted she had fabricated the rape, but also why she had done it. She was upset because the person had used her. She had voluntarily had sex with this young man, and then when he left the party and went off with someone else, she was mad. She eventually told somebody about this. It turned up through a background investigation. The other thing that we have found out is that they definitely will talk about events differently to their friends than to their parents. So find the friends that they have talked to. There is another type of background information. It is easy to spot. You hear about a child coming forward because she was afraid that she was pregnant and that she was molested by her next door neighbor, and she was a virgin. Then I look through the report and statements, and she mentions that she was a virgin again. And then later on in the reports, she mentions that she was a virgin again. And I start thinking, thou dost protest too much. We went out and did an investigation, and within one day found out that on Tuesdays and Thursdays she was with her young little boyfriend having sex while Mom was at work, and she didn't want him to get in trouble. We found the boyfriend, and he owned up to it. Was that an isolated case? No. We've had 5 or 6 cases identical to this. What's nice about those cases is that they never go to trial. Find their friends, and more importantly, children have enemies. Find their enemies, and they will tell you what's going on. Next, I'd like to introduce you to our investigator, Harvey Shapiro. Mr. Shapiro teaches POST, Advanced Officer Courses. POST, as you know, is Police Officer Standard of Training. He is a consultant on the latest POST training video on the investigation of allegations of sexual molestation. He handled a couple of thousand molestation allegations in his career because he was a child molest investigator for the Riverside Sheriff's Department. Not only that, he was also trained by Stephen Ceci himself on issues of suggestibility. Harvey is going to talk to you about the role of an investigator. I'm proud to introduce to you Harvey Shapiro.
My name is Harvey Shapiro, and I'm an investigator for the Clancy Litigation Group. I want to thank PsychLaw for inviting me to speak here today. From 1974 until I retired, I was a detective in the Riverside County Sheriff's Department assigned to the Crimes Against Pattern Analysis Unit, the Law Enforcement Intelligence Unit, and the Crimes Against Persons Unit. Allegations of child sexual abuse and child physical abuse are handled by the Crimes Against Persons Unit. During this time, the country was rocked by sensational cases such as the McMartin preschool case and the Bakersfield sex ring cases, and many more. These cases were based upon investigations that went out of control. Fortunately, we didn't have problems like this in Riverside County. Certainly, we had our share of accusations. So how did we avoid these types of problems created by investigations that went out of control? Command instructed us to do investigations as if we were defense investigators. That's right. I was told to conduct my investigations as if I was the defense investigator. If you're searching for the truth, you must be as concerned about those that are innocent as you are about those who are guilty. This attitude helped us avoid approaching a case with a single hypothesis and motivated us to explore other possibilities of how something could have occurred. Today, as I do investigations for the defense, I'm encouraged by law firms I work for to conduct an investigation as if I were the police. Why? Because good defense attorneys are concerned with what is out and what facts a good investigation will uncover. Today, as I do investigations for the defense, I'm encouraged by law firms I work for to conduct an investigation as if I were the police. Why? Because good defense attorneys are concerned with what is out there and what facts a good investigation will uncover. Good defense counsel want to know what is out there that can affect their case, and they want to know it as soon as possible. Today I want to talk to you about what a competent investigation entails, whether that investigation is conducted by law enforcement or by the defense. The information I'm going to give you today comes from, in large part, the presentation that I give to law enforcement when I do training programs for POST, Police Officer Standard of Training. It doesn't matter what the audience is made up of, law enforcement professionals or defense investigators, the message is the same. Search for the truth. The investigator is supposed to be the finder of fact in the search for the truth. It's important that the investigator assist the attorney at trial, whether that attorney is the defense attorney or that attorney is the district attorney that the investigator is assisting. The assistance is based upon the investigator's search for the truth, and in the search for the truth, reliability is the key. For us, reliability means, 1, are there sufficient corroborating facts supporting a conclusion? 2, will it hold up to scrutiny? 3, will it hold up over time? It is important to understand that when any investigator looks at a case, They want to be concerned with the reliability of the information contained in the case. Bias affects that reliability. One of the most important kinds of bias an investigator needs to watch for is called confirmatory bias. In its worst form, this means driving towards a specific conclusion, no matter what the evidence may be. Confirmatory bias is widespread. It can be overcome only with specialized training. It is especially important to learn to ask the right questions. We must guard against focusing only on "he did it" or "he didn't do it" kinds of information. We can guard against confirmatory bias by trying to look for the whole picture. Number one, who made the initial allegation? Number two, what were the circumstances of the initial allegation? Number three, who stands to gain by the allegation, and so on. This is the groundwork an investigator will lay down to help guard against confirmatory bias. We must also consider coercion. This can mean manipulation by someone with something to gain by the allegation. It can mean an overzealous interviewer mishearing a child, or worse, it can mean covert threats, which almost any investigator will work to uncover. Investigators should carefully review audio and videotape interviews, whether they be of witnesses, or the victim, or the suspect. I teach that good investigators must interview the suspect concerning the circumstances and his state of mind during any admission or confessions he may or may not have made, either in the interrogation arena or in the pretext arena. The pretext arena refers to pretext telephone calls made by the alleged victim to the suspect that is recorded by the police investigators. An investigator must carefully review the circumstances and the state of mind of the defendant in both of these areas to uncover coercion, misinterpretation, or misunderstandings. At the Clancy Litigation Group, we find that chronologies and witness lists are of great value. It is the client and the investigator that put the chronology and the relevant facts together for the attorney. This helps create a context for events and serves to guide the investigation and the trial preparation. This is of great importance because absent the context of how something occurs, it's very difficult to form an accurate picture. Another important factor in any good investigation is to develop evidence on the credibility of all witnesses. Do they have any motives to lie? Do they have any motives to get back at someone? We also take a look at issues of source monitoring, and this generally means to the source attribution and source misattribution. Dr. Lorandos tells us more about this in the seminar on suggestibility. Let me just say that source monitoring refers to the process of identifying the origin of one's knowledge of events. Maybe someone has a memory, but did that memory come from an actual event, or from just thinking about that event, or from the event being suggested to them? My friend Dr. Elizabeth Loftus has done a great deal of important research in this arena, and a great deal of that research is presented in the seminar on suggestibility. It is also important to remember that as people, we tend to look for things that support our own personal point of view. As investigators, we must look at prior interviews that have occurred for indications of such bias. These indications are sometimes apparent because of the complete lack of prior interviews or any attempt to think about or search for any alternative hypothesis. Remember I talked about guarding against focusing on only "he did it" kinds of information? It's crucial in a good investigation to determine whether interviews looked at any alternative hypothesis other than "he did it." We look for, as we say in psychology, the pursuit of alternative hypotheses. Are there other possibilities of how this event could have occurred? In general, we try in our interview process to examine other possibilities. The investigator will also consider confessions and ask, do you have any coerced confessions? Professor Leo has spoken a good deal about this. I would add that the objective investigator will not take a confession at face value, but will investigate whether the suspect was scared, or look into the possibility that maybe they said what they said because they thought it would help them with less jeopardy. We must also look for factual disclosure that only a person that is guilty would be aware of. These are but a few of the important issues for psychologists and good investigators to answer. Let me also say that we must carefully look at the medical reports. Medical reports may or may not confirm that which is alleged. At the Clancy Litigation Group, we maintain a strong medical library which we use to examine medical reports. We know that a good investigator will investigate issues of opportunity, motivation, and sexual knowledge. It's how an investigator looks into these important concerns that I want to talk about now. When conducting interviews, the skilled investigator will be concerned with the reliability of the information provided. There is significant research regarding the issues of memories and malleability of memory. One of these important malleability issues is coercion. An investigator should work to determine if coercion was used with any witness, and if so, as a result, the individual may assent or accommodate and give the story that they gave to minimize the possible negative outcome. The concerned investigator will also work to determine whether the information provided by any of the witnesses or victim was based in any way on the suggestibility of that person. Also, the investigator should look at the possibility of implantation of non-events. Analyzing interviews, the objective investigator will look at issues of misunderstanding, that which may have occurred, or the misinterpretation of what actually did occur. Cultural differences should be explored and how events might be viewed differently or misinterpreted by other nationalities. Remember, it's important to maintain excellent communication with your family, the accused, the witness, and their family. It's important to stay in contact with the defense attorney when you're working for the defense, or if you're a law enforcement officer, to stay in contact with the district attorney. Let me talk a little more specifically about forensic interviewing. The role of the forensic interviewer is to be objective, and that means that the interviewer is committed to eliciting facts without imposing his or her own beliefs on the person being interviewed. The objective interviewer needs to be neutral and consider alternative hypotheses. The interviewer needs to be friendly and not present as an authoritarian or disciplinarian. This will aid in the free recall of the interviewee. It's important to attempt to interview the alleged victim or victims. This might not be allowed or available to the defense, but it's important for law enforcement to maintain excellent communication with those folks. In these important interviews, some helpful things that you can say are, number one, I wasn't there, so. Number two, even if you think I know it, tell it to me anyway. Number three, even if you think it doesn't matter, tell me anyway. Number four, it's okay to tell me that you don't remember. Number five, it's okay to tell me you don't want to answer my question. Number six, if I make a mistake, please correct me. Another very important issue for the competent investigator to be aware of is to know the difference between a therapeutic interview and a forensic interview. There is a difference between a forensic interview and a therapeutic interview. Here's an example. The therapeutic interviewer assumes that the child is telling the truth. The forensic interviewer interviews for the purpose of fact-finding. In a therapeutic interview, the interviewer is an advocate. In a forensic interviewer, the interviewer must be neutral. In a therapeutic interview, subjective reality is accepted. In a forensic interview, alternative explanations are explored. In a therapeutic interview, accepting a general description of abuse is accepted. In forensic interviewing, details of abuse are imperative. In therapeutic interviews, information can be obtained by using a variety of techniques. In forensic interviews, the interviewer follows a set of guidelines that are generally accepted within the interview community. What we do as interviewers, whether we be law enforcement or the defense interviewers, is attempt to find out how people know what they think they know. Just because they think something is so doesn't make it a fact. What's important to understand that if a person doesn't know what the truth is, how can they possibly tell a lie? Remember, reliability is the key. And don't forget that the thorough investigator will carefully review the work of the previous investigator or investigators. Remember, reliability is the key. And don't forget that the thorough investigator will carefully review the work of previous investigators. The investigator, along with the attorney, should review the training records of law enforcement officers and child protective service people to see if they have had specialized training as required under California Penal Code 13516. As you know, this law requires law enforcement people to have specialized training in sex crimes. When we review the medical and psych records, as well as photographs, we may find that there is a conflict between what the report says and what the evidence shows. While interviewing, it's important to get as much information as you possibly can. Like the little dots or pixels on the picture, the more pixels in those pictures helps determine how clear the story will become. So it's important to get as much information as you can with as much detail as you possibly can. Remember, the greatest impediment to progress is not ignorance, but the illusion of knowledge. Let me give you an example by showing you a few slides. Take a look at this slide. It's called the sign painter. In viewing the first slide, I want you to think about what the sign painter is drawing or painting. You will see on the left side there is some information. On the right side, the sign painter has provided additional pieces of information, suggesting a more vivid idea of what is to come. Now we take a look at the second slide, and we see the picture on the left with more detail and more information. Now we're getting even a more clear picture or idea of what the sign painter is painting. Take a look again. On the right-hand side, even more detail, even a better look at what the sign painter is trying to portray. Take a look at slide number 3. We see a lot of additional detail, and now we're probably sure that we have a good idea of what the sign painter is painting. All too often we stop at this level. We do not wait to get more information because we think we have the answer. If we would have continued further without forming an opinion, we would see that what we thought the sign painter was painting was in fact not what he was painting at all. So we can see by this example the details are very important for investigators, whether they be the defense or the prosecution. It's important to obtain the most pixels of information that you possibly can so that you can see that clearest picture. Most importantly, the investigator is not an advocate. The competent and thorough investigator must look at both inculpatory and exculpatory information. This means we must look for information that tends to show that a crime has been committed and information that tends to show that a crime has not been committed in searching for the truth. In my observation as a retired detective and my observation as a private investigator doing child abuse cases for many years, when the investigator keeps an open mind, tries to obtain as much information as possible, investigates all reasonable alternative hypotheses, they will get the information they need to help prove or disprove that the one that has been arrested or they have arrested or are planning to charge will get justice. Thank you.
We want to thank Harvey for explaining to you the role of the defense investigator. And in fact, it really shouldn't be called a defense investigation because a true investigator goes after the truth. He goes after the facts, whether they are a police investigator or whether they're hired by the defense. Now you should realize that an investigation is the backbone of a case. It's not attorneys. It's not expert witnesses. It's investigations. On behalf of Harvey Shapiro, Professor Leo, and Dr. Lorandos, I want to thank you very much.